contrary to the decision taken by the Parliament Act, AP Reorganization Act. My senior colleague is Jairam Ramesh. This is a capitalist inside.
केवल वंदना चौहान जी का रिकॉर्ड में जाएगा जो 15 प्लीज यू प्लीज रविंद्र कुमार जी प्लीज 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 आपका समय समाप्त हो गया प्लीज आप बैठिए वंदना जी
Sir, thank you, sir. Sir, I stand to support the bill which has been put forward. And like my other colleagues, I would like to flag some of the concerns that I have regarding the judicial system. Sir, we all know. Please, let me talk.
Please, please. केवल वंदना जी जो बोल रही हैं वो रिकॉर्ड में जाएगा.
Sir, let my time start from now. Sir, like my other colleagues, I would also like to flag some of the concerns and some of the issues which plagues our system. So, and the topmost on this list is pendency, as a lot of my colleagues have already said. So, today, 4.5 crore cases are pending in the courts, and the COVID-19 situation made it worse than what it was earlier. Just to understand the seriousness of where actually the attention of the government should be given, and where is the bleeding for help actually happening, I would like to give a breakup of the pendency. So, according to the data from the National Judicial Data Grid and the Supreme Court, 3.9 crores cases are in the district and subordinate courts which are pending, 58.5 lakh cases in various high courts, and 69,000 in the Supreme Court. So, it's the same everywhere. But the worst thing is that the district court and the subordinate courts, unfortunately, do not get the kind of attention that they need to get, and therefore I want to draw the attention of the Honorable Minister to this issue. Sir, in an article written by retired former Supreme Court Judge Markandeya Kajju, sir, in 2019, when the pendency then was only 3.3 crores, he observed that even if no fresh cases filed, that means that time in 2019, it will take 360 years for the backlog to be cleared. This is the seriousness that we are talking about. And sir, we have to also see that one of the incidents which makes this even more loud and clear is when the former Chief Justice of India, Tirath Singh Ji Thakur, actually broke down in a conference of the CMs and the Chief Justices of all the state, just to bring to the light that the kind of stress that all these judges carry on, and it's like a hanging sword for them. So this is the kind of seriousness. Time and again, reports, documents, debates have talked about pendency, but unfortunately not much has been done. I know that it may be a repetition of some of my colleagues already said here, but I would like to reiterate some of the points. So one, filling of vacancies is absolutely important. More than 400 judges' positions in various high courts is still pending. Secondly, sir, a whopping 5,000 vacancies in lower judiciary is pending. Sir, to address the long-standing demand, we need to address some of the issues. And one is that there has been a constant demand that the retirement age of a high court judge should be extended from 62 to 65. I mean, this is so simple. Why aren't we doing this? If there is a pendency, there is a backlog of appointments, why aren't we making this simple step to take it forward? Second, sir, we have to, as a lot of my colleagues have already said, that we must ban positions after retirement, because this is something, I mean, if we realize that they can be given a tribunal and they can be appointed there, that means they are healthy, their intellect is in place, and therefore why not extend this age? So it is easier to extend rather than appointing them in other tribunals. So another thing that we have to see, that there has been a constant demand that there must be an all-India Judicial Commission. Just like the IAS, IFS officers are appointed, judicial officers, especially in the lower courts, must go through this kind of commission, and this is where our vacancies can be filled up very well. I'm just touching upon the points and not elaborating. So another thing that is absolutely important is to upgrade the infrastructure, especially in the subordinate courts. I just spoke about 90% of pendencies in the subordinate courts. Sir, the judges, the court staff, and even the litigants, you go to a court. So I would urge the Honorable Minister to please just visit some court sometime. You are just surrounded by files and folders and papers. You start sneezing because they've been lying there for years together, taking dust. Secondly, if you visit, you don't even have to go to a toilet. If you're just passing the corridor, the whole corridor is smelling of methane gas, ammonia gas. I mean, what are we doing? Can't we have a decent infrastructure for the litigants who spend the whole day over there when they come for the cases? This must be a priority given under Swachh Bharat Abhiyan. And I'm really surprised how this government has not thought of this. So this is another important thing. Sir, use of technology and adoption of digital solutions is absolutely important. During the COVID times, we saw that the High Court and Supreme Courts did adopt this technology. People staying all over could attend courts in any part of the state or anywhere for that matter. Unfortunately, the district courts did not have this kind of infrastructure, and therefore the courts couldn't function, the witnesses couldn't come. In fact, the courts were closed. So why don't we work towards this direction, that we must have the use of technology and adoption of digital solutions, even for the district courts? That is where the backlog is, and therefore that is the thing where we need attention. And therefore the need for National Judicial Infrastructure Authority is absolutely, absolutely important. Coming to my next point, sir, we have made laws on alternative dispute resolution mechanisms. We have made amendments. Even in 2015, we brought about few amendments. Unfortunately, this is a robust system, no doubt. But unfortunately, the arbitration, mediation, and conciliation mechanisms which should be adopted are not being adopted. And it is an unfortunate situation that even most of the lawyers probably don't know about this. So it's very important that there has to be a supportive system. There has to be an enabling environment where the government proactively reaches to the lawyers and makes them understand that these are the provisions which are available to make sure that the litigation can reduce. And especially in civil cases and minor criminal disputes, this could be the best solution. Next, sir, the capacity building of judges. Yes, judges have been former lawyers. They have been passing very good judgments. There are wonderful precedents. But in some of the tribunals, sir, like the NGT or many others, unfortunately, they don't have the expertise of the subject. So it's very important that a law academy should address all these subjects so that they empower the judge to understand the issue and really see it in the light, especially the NGT, sir. We talk about climate change issues. We talk about how we need to mitigate and adapt that. But if the judge doesn't understand what is being pleaded, it is absolutely something that we are losing on. And therefore, that is something which we need to do. There has already been a demand on division of the Supreme Court into a constitutional and other legal branches, alternatively creating regional courts of appeal. So I will not elaborate on that, but I will also reiterate that demand. This has been a demand for a very, very long time and needs to see the light of the day. The next point, sir, is to rethink. We did pass the National Judicial Appointment Commission Act. Unfortunately, it was struck down by the Supreme Court. We have to have consultations with the judiciary to find out via media to see how the judicial appointments to high courts and Supreme Courts could be done, because we will have to do away with the collegium system, which is definitely a defect in our system. My last point, sir, in the words of Chief Justice of India, N.V. Ramanna, the present Chief Justice, he said that an urgent correction of the gender imbalance in the Indian judiciary has to be made. And he has advocated that 50% positions on the judiciary must go to women. It is an irony, sir, that behind every judge there is the Lady of Justice standing. Egyptian god called Themis, I don't know whether I'm pronouncing it right, or the Greek goddess Maat. Unfortunately, she stands there behind the seat, but doesn't sit in the seat. That is an unfortunate thing. So I think this government, with such a thumping majority in both the houses, must make sure that 50% women are included in the judicial process. Sir, my last point, which I want to reiterate, that coming back is to the pendency. Pendency is amounting to delayed justice, and justice delayed, as we all know, is justice denied. I want to draw the Honorable Minister's attention. So we make laws here. And all these laws are based on established universal principles. They are based on human rights. Look at the two examples that we see in recent times. One very, very senior Supreme Court judge, Mr. X, was accused of sexual harassment at workplace. We passed the POSH law. The law says that you have to appoint an internal complaints committee, an ICC, and the ICC will scrutinize the evidence and then pass the judgment. Why was he made an exception? And if you want to make an exception, do make it in the law itself. You cannot have arbitrary things. Secondly, sir, my last point, sir.
Please.
Secondly, sir, even in what is the point of order? This is, I'm not yielding. I'm not yielding. Sir, I'm not yielding because this is a fact. This is a fact that I'm talking about.
Point of order, it is up to the chair.
This is a fact that I'm saying. This is a fact.
Sir,
under which?
It is there in the rule.
Sir, this is a fact. What point of order can be there? This is a fact. Sir, and my last
or
point.
a member of the other house, you cannot make comment on him.
So what
that is the rule. That is the rule. That is the rule of this house.
Under which
This is the rule of this house. That is the tradition of this house. Everyone knows about it. If you do not know, if you do not know, please read it.
Please, I'm asking him.
Sir, my last point. When we pass laws here, we enact laws here, we pass them in view of natural justice. We have to make sure that both sides have to be heard and everybody has to be given an opportunity. So it is so unfortunate that in the parliament we suspended 12 members, but we did not give the opportunity to say their say, and that was the thing of natural justice. Thank you, sir, for giving me a hearing.